talk about the Rowley Act. We've already talked about this in prior presentations, but it's basically the one that told the school districts, hey, you don't have to provide the Royal Royce, the Jaguar services. You can provide the Ford Pinto, right? You provide the basic floor of opportunity, sufficient to confer some educational benefit that is reasonable. Now, all fair hearings and all law and special education, if you look here in the middle of the page, you see sufficient to confer some educational benefit, reasonable at that time, not in hindsight. That's very important to remember. An IEP team must make the best decision with the information they have at the time. Later on, when the parents take the district to court, the parents can't say that, 6 months later, it became obvious that this was the wrong choice. They have to stick with the information that was available the day of the IEP meeting, the day the decision was made. And so hindsight is not a factor. You act with the best information you have at the time. And you're always acting in the best interest of the child, not the teacher, not the district, but the child. As long as you do that, you're okay. If that information changes, it is necessary for us then to change our services or to address that change in an IEP meeting. Let's say you hold an IEP meeting and the kid does not qualify for OHI, but they are receiving SLD services. 2 weeks later, the parent comes back with a doctor's diagnosis of ADHD. Now, you tested the kid for OHI, so presumably you gave them some assessments for ADHD, like the Conners Continuous Performance Test. You gave them the BASH, you gave them the Conners Parent and Teacher Surveys. A diagnosis of ADHD doesn't change the eligibility, but the IEP team should hold another meeting, incorporate that information, and reconsider the possibility of eligibility. Just because your psychoed didn't qualify the kid under OHI doesn't mean that the IEP team cannot just go ahead and qualify the kid under OHI. Qualification is an IEP team decision. It is not our decision as school psychologists. We do determine eligibility, but we don't determine qualification. And so the team could decide to act on it. The important part is that you met to discuss this new information. Should you ignore it and not meet, then you open yourself up to liability and to the district. So the Rowley Act goes on to specify that you cannot you cannot rule in or rule out eligibility based on one test. Benefit may be gained by the student if some of the goals are met. They don't even have to meet all the goals. And grade level performance obviously is not necessary. We all know those students in SDC who will never be at grade level. According to the Rowley Act, they don't have to be at grade level to be making progress. We just have to make sure they're making progress on some of their goals. It eliminated an undue burden on school districts to maximize every child's potential. And we think, wouldn't we want to do that? Yes, as human beings, yes, as educators, but there's limits. There's limits as to how much we can spend to make that happen. And so the Rowley Act gave the school districts a break. Now, the Rowley Act does include parent participation, and we're going to talk much more about what parent participation is later on. But you must be able to document it. You must be able to place equal emphasis on the student and the parent, on the services and the parent, on the advice of the speech and language pathologist and the parent. Basically, the parent gets equal say in everything. Keep them informed. Now, what's neat about the Rowley Act was in March 22nd, 2017, the U.S. Supreme Court said, wait a minute. The Rowley Act was appropriate for that particular case. That kid's last name was Rowley. They said that IEPs must actually provide meaningful education benefit. And it has to pertain to that student's current situation. So, in other words, they said it has to be individualized. It can't be just progress on goals. If that particular student is capable of making more progress than just progress on goals, and all you're doing is measuring progress on goals, you've not provided FAPE. In fact, you've denied FAPE. The Supreme Court did not define meaningful, and I think, well, as with most things law, that's intentional. That leaves it up to the courts and the due process proceedings to define what meaningful looks like for that particular student. In the Rowley case, the child was an SDC child, out of general education all day long, no chance of grade level performance, no reasonable chance. The 2017 case, the child was autistic, pretty high functioning. The district had put the child in an autistic program that was an SDC class, not expecting classroom performance, grade level performance. And so what the parents did is they pulled the child out, put him in a private school for autistic children at a cost of $70,000 a year. But you know what? That kid thrived. He ended up performing at grade level, something he would have never done in the district with the district's offer of FAPE. So the district said, hey, wait a minute. He was making progress on his goals, so we met Rowley. We met the basic floor of opportunity. And the Supreme Court, actually it was upheld at some of the lower courts, but when it got to the Supreme Court said, no, you didn't. This child obviously had far more potential for grade level work than you had, than you were providing, or than you had acknowledged in the IEP, so therefore you denied the child FAPE. And of course, they were reimbursed the tuition for the school. So, districts must develop an IEP that is reasonably likely to have a meaningful education benefit in light of the student's unique circumstances at that time. Basically, guys, what this means for us is that the more individualized the IEP is, the better. And this will be a constant challenge for you, for the SAI teachers, for your speech and language pathologists, for the OTs, because we're all human beings and we all like to work with the tools we have. If we don't have to learn anything new, let's not. If we don't have to change things up, let's not. But that's not going to fly anymore. Okay, look up that Supreme Court decision if you get a chance. It's a real interesting read.